Hello, everyone. I see this is Paul Blaney. Welcome. Thank you for joining us today. This is our first estate planning workshop via Zoom. So please bear with me. This is the first time I've actually hosted a Zoom forum, but we have hosted estate planning workshops in person many times. So please bear with us as we navigate how to run this workshop effectively. But a few housekeeping things before we begin. We will have a chance for everyone to introduce themselves, but I wanted to introduce myself first. I'm Paul Blaney. I am the manager of individual giving at LightHouse. I'm accompanied by my colleague, Andrea Vecchione, who is the events manager at LightHouse and our co-host today. And I will introduce our speaker, Kevin, in just a moment. So thank you all very much for joining us. I have two computer screens going here, so don't mind me if I look away. We are still waiting for a few more people to join us. So let's hold on for just a second. I see Kevin is here. Eleanor, you're here. Welcome. I see Wen Ross. Jennifer Sachs is joining us too, and Jennifer is our Director of Development. Who will be joining us today. She may have some comments to add during our workshop. I see a couple of other phone numbers. I don't see names attached to those, but you can certainly introduce yourself when we go around. So looks good, looks good. Wonderful. Okay, we will begin. So again, thank you very much for joining us. We're hoping to keep this workshop to an hour and a half. We are recording this workshop, so you'll get a copy of that upon completion, and I'll follow up with everybody directly. We have a chat feature. For those of you that are familiar with the chat, you can certainly drop some questions in there if you want to use the chat, and if you don't want to use the chat, then we can address some questions towards the end. We do only have an hour and a half, so we'll probably limit the questions to maybe 2 or 3, but you will have an opportunity to follow up with Kevin directly. You can certainly follow up with us, and we can get all of your questions addressed. So no worries there. We will be presenting some slides today. Kevin will go through a series of PowerPoint slides. We'll advance those slides for him. We'll probably move pretty quickly through those slides. Again, if you have questions, we can follow up at the end. And I wanted to just give a little bit of background on LightHouse and what we're doing right now during the COVID-19 shelter-in-place ordinance, and a lot has changed for us, but I have to say that we are keeping our community really strong. Our students are connected remotely, and we are extending all of our workshops and classes to our students remotely. And we're also checking in with everybody, something that's new for us, just calling people on the phone, finding out how people are managing, what they may need, and keeping them connected to other people. There's lots of forums going on, virtual campfires and events, concerts and things that people are joining. So we're at least able to hear each other's voices and stay connected. And we're hoping that we're going to, be back at 11:55, maybe by September. We don't know. That's just a shifting date, but our community is still really, really strong. To talk a little bit about legacy giving, some of you may already know or already have plans in your estate to name a beneficiary. And LightHouse has this legacy giving program where you can identify LightHouse as a beneficiary in your estate if you like. That's why Kevin is here to talk to us. He's an estate planning attorney and can tell you more directly about how to participate. We have about 40 active participants right now. Those are people that have come forward to say, yes, LightHouse is included in my estate plan. If it's something that you would like to initiate after this workshop, you can certainly talk to me and I can connect you directly with Kevin, or you can contact Kevin directly, but we're welcome conversations about this because we know that there's some sensitivity around that, and things may change as time unfolds. But we do have a program here at LightHouse. You can leave a gift to LightHouse through your will, beneficiary designation that I just mentioned, charitable gift annuities, and we'll talk a little bit more about that as the workshop unfolds. So I want to take this opportunity now to just go around the forum virtually and have people introduce themselves. I will reintroduce Kevin at the end of that so he can take it away and talk more about himself and present the program. But we have a special guest here today. I hope he's here. His name is Jorge Ellington, and I want people to know a little bit more about Jorge. And it looks like Jorge may be calling in on a phone number because I don't see a name associated with Jorge. But I wanted Jorge to talk a little bit about the community Lighthouse and his connection to what we do. And then after Jorge is done introducing himself, I want to go quickly around the virtual forum and have people just state their name and how they're connected to Lighthouse. We would like to hear everyone's story about everything that they're doing right now. We may have some time in the end to engage more informally, but we need to keep to a time restraint. So I just ask that people introduce themselves by their name and how they are connected to Lighthouse. Now, Andrea, I think I have to unmute to find where Jorge is because I don't have his name. I only have his phone number. So can you help me with that?
Yeah.
Okay. Bear with me just one moment. I do have Jorge's phone number in my phone, and I might be able to identify it that way.
Or Jorge, you can just go ahead.
Hey, Paul.
Yeah, that's
Paul?
better. Are you there, Jorge?
Paul? Yeah, that's me. I've been here.
Oh, okay, good. Thank you, Andrea. Thanks for helping.
I just unmuted myself.
That's perfect. Thank you for saying that. So when people need to introduce themselves, you can just unmute yourself, or we might be able to unmute everyone. That's something I've not done before. But Jorge, thanks for joining us. I know you've been a part of Lighthouse for a long time. Will you tell the group, please, just a little bit more about yourself and how you're connected to our work and why you might be interested in estate planning?
Okay, I've been at the Lighthouse now. In fact, it'd be a week. I'll be there 4 years. I'm also a student and a volunteer. I volunteer with the Hispanic students. I translate Spanish with the Hispanic students, and I work with some of the instructors there, and some of them were my instructors, and I also work with those instructors as a translator, Spanish translator. I came to the Lighthouse 4 years ago. I was one of the first group that stayed there, the immersion, the 5-day immersion that's coming up. I think next week will be 4 years. My involvement is only as a student and as a translator. The Lighthouse has helped me a lot. You know, my blindness is about 5 years old, and without the Lighthouse, I would be still trying to find a way to, you know, maneuver myself, learn the technology, the braille, the orientation, and mobility. I'm interested in today's program because, as you said earlier, you know, estate planning is something, you know, we all should be interested in, and I'm also interested in, you know, estate planning and what to do. And this is my first time to connect to estate planning.
Excellent. Jorge, thank you. I've known Jorge for a while, and he's quite an amazing part of our community. He's always eager to get involved, and I know we have a project coming up together, Jorge, next week, so I'm looking forward to that. So thank you very much. I'd like to take this time now to kind of go around the table, so to speak, and have everyone just introduce their name and how they're connected. So I think what I'll try to do, and bear with me, is I do see some faces and I do see some names. So I'm just going to call on people. However, there are just phone numbers at the bottom, and I'll get to those in a minute. So Kevin, I see that you're here, and I've actually unmuted you. So welcome, and tell us a little bit about yourself.
Thank you, Paul. My name's Kevin Oshiro, and I live up in Novato. It's the wilderness of Marin. And I became familiar with LightHouse about a year and a half ago. My glaucoma was starting to actually impinge on being able to live comfortably. And so I wanted to kind of get ahead of the curve in terms of learning what I needed to learn. So to that end, I've participated in the orientation and mobility program through LightHouse. And then more recently, I've been involved with the employment immersion program. And that's been a life changer for me, because thanks to that particular portion of LightHouse, I was able to get a job with the City of San Francisco, and I will be starting my new position in about a week or two. So I'm thrilled, and LightHouse, it's like, awesome.
Awesome. Kevin, thank you. Yeah, we met you at the staff meeting the other day, and nice to hear from you again, and thank you very much for joining us. I'm going to mute you now. I see Sheila. Sheila is next, Sheila Bonito. I have to actually, looks like I have to ask, oh, there we go. Sheila, hi.
Hi. I'm a teacher visually impaired since 1975, so I've brought many, many, many students up to Enchanted Hills, participated in many of the programs with my students, and I'm also the step-parent of a child who's now 32, developmentally delayed and visually impaired, who's attended Enchanted Hills since she was about 9, almost every year. And so I'm heavily invested in Enchanted Hills and helping her be less disappointed in not being able to see all her friends this summer.
Yeah.
Trying to get her involved in the campfire things. She lives in a group home and they're having intermittent phone problems. So, I mean, it's just a challenging time. But yes, I do want her to have a place that she can go to the rest of her life.
Fantastic. Sheila, thank you. Your name is very familiar to me. It's nice to see you, and thank you. I'm going to mute you here, and I'm going to move on to Eleanor. If you could just tell us your name and how you're connected to our community, please. I have to ask to unmute, it looks like. Let's see what I'm going to do. Andrea Vecchione, you may need to step in here. I see an icon that says ask to unmute.
Eleanor can unmute herself if she...
I think maybe. There we go. Hi, Eleanor. It's Paul.
Hi.
We'd love to you just introduce yourself and how you're connected to LightHouse, please.
Yeah, my name is Eleanor Liu, and back at the end of 2012, I lost my sight in my right eye in 1 second. And I searched everywhere. I called every hospital and school that I could think of, trying to get help. Finally, there was somebody who told me there was a support group for people with quote unquote low vision. I didn't even understand what low vision meant. And as a result of my experience, I wrote an article that was picked up by the New York Times about 6 years ago, talking about my experience. After that article came out, the LightHouse contacted me and said, would I like to be part of the camp, the immersion program? And I did not know that it was even around. And it took me a year to say yes, but I finally accepted, and it was wonderful. My life was totally changed as a result. Then I wrote a second article. Again, it was picked up by the New York Times. You have to remember, not once in my life did I ever think that I would ever write anything that would be published by the New York Times.
Wow. Wow.
So that's how I became involved with the LightHouse. And now I facilitate a low vision support group, something that really saved my life in the first place. But I do this group. The group meets in Berkeley.
Eleanor, thank you. That's an amazing story. I haven't heard that before. So thank you for joining us. I'm going to mute you again, and I'm moving on to Wen Lin. I'm going to ask when for you to unmute yourself if you can. Let's see.
Okay, Paul,
There
can
you
you hear?
are. Yeah, we can hear you. Hi, welcome.
Hi, my name is Wen Lin. I have been a student of Lighthouse for almost 10 years. I'm low vision and I participated in all sorts of programs like immersion program, the camp, mobility orientation mobility, and access technology. And I have really greatly benefited from all the programs offered by Lighthouse, and also made friends with people at different level of vision loss. So I really appreciate the program, and it's great to learn something new in estate planning. That's why I'm here.
Excellent. Wen, thanks for joining us. Nice to hear from you. I'm going to mute you again. Moving on to Ross. Ross, if you could tell us your name, please, and just briefly how you're connected to Lighthouse.
Good morning, everyone. My name is Ross Ojeda. I live in the East Bay, and I learned about the Lighthouse from Kaiser Ophthalmology Department after I was diagnosed with severe glaucoma. And I participated last year in their summer camp in Napa, which was a wonderful introduction into the low vision world of seeing differently and acting differently. That's been my limited experience, and I look forward to continue participating with Lighthouse and other people I've met in their programs.
Excellent. Ross, welcome. Thank you very much. I'm going to mute you again. Jennifer, our Director of Development, is here. Jennifer Sachs. Jen, do you want to say hi to everyone? I'm going to unmute you.
Hi there, this is Jennifer. I'm the Director of Development. I'm really thrilled that you're all here. And Kevan Warren, I'm looking forward to learning more about estate planning from you. So I hope it's a wonderful morning. Thanks.
Thanks, Jen. Okay, now I'm moving on to someone that is listed as iPad 2. I don't see your name, but I'm going to ask you to unmute. And I'm not sure who this person is, but we shall find out. iPad 2, I'm asking you to unmute. You should have that option to do that. If you can't, I can come back to you. I think I may do that. Okay, I'm going to move on to Arnold. Arnold, hi, it's Paul. You want to introduce yourself and tell us how you're connected to Lighthouse?
Yes. Hold on. Okay, hold on.
We can hear you just fine.
Good morning, everyone. Actually, I'm from Southern California. I'm from another Braille Institute. I'm a formerly student of Braille Institute. So I'm actually, I guess, your guest. Yeah. I'm a former student of Braille Institute before, and then I took up some computer classes and mobility classes, and then afterwards, I went into a massage therapy, and I'm now a massage therapist.
Awesome.
Yeah.
That's awesome. And you're in Southern California?
Yes.
Oh, good. Welcome. Thank you, Arnold.
Thank you, guys.
Nice to meet you. I'm going to mute you again. Moving on to MJ. MJ, I'm asking you now to unmute if you'd like to say your name and how you're connected. Welcome.
Oh, hi. My name is MJ, and I was a student at the Lighthouse. I took my mobility lessons there, and I am also a volunteer at the Lighthouse since 2018. And I am looking forward to learn about more of estate planning with you guys.
Excellent. Well, welcome. Nice to meet you. I'm going to mute you again. And I'm moving on to Kenneth. Is that right? Kenneth? I'm sorry if I'm mispronouncing that, but welcome. I'm Paul. Please introduce yourself and tell us how you're connected to Lighthouse.
Sure, Paul. So I'm Kenneth. I'm a TBI. I work for the Mid-Alameda County SELPA, as well as my dad is a client of the Lighthouse. So he has glaucoma, like another caller mentioned on the call. And he's also dealt with cataract surgery that went really well recently. So I'm calling in on behalf of myself and as well as for him. He's doing something else at the moment, so I'm taking notes for my family and myself.
Thank you. Nice to meet you. We are recording this as well, and I can send you a copy of that so you can share it with them if you'd like.
That would be wonderful.
Yeah, I'll do that. And nice to meet you. Thanks for joining us. I'm going to mute you again here. Okay, I have 2 more people to go, it looks like, but I only have phone numbers for these people, so I don't have your name, and one of them may be Jorge. This person, I'm going to ask you to unmute, and it looks like you are unmuted, so if you can introduce yourself and tell us how you're connected to LightHouse.
Hi, I'm Evelyn Liu, and I became a client a couple of years ago when I purchased an iPhone. I'm totally blind, so I got training on how to use it.
Oh, that's
and
awesome.
Hope to, yeah.
Thank you. Now, nice to meet you. Thanks for joining us. I'm going to mute you again. And this last person, I think maybe Jorge. I've unmuted you. I only have a phone number. Is this Jorge?
Yeah, is it 282?
Yeah, that's you. We got you. So thanks.
All
I'm going to
right.
mute you again. Okay, thank you very much. All right. Nice to meet everyone. Thank you for joining us. That was really smooth and really great. Nice to meet you all. And now I would like to turn it over to our presenter today, Kevan Warren, who is an estate planning attorney and can tell us a little bit more about what he does, how you can connect with him, and then he's going to move into a slideshow for us. And again, we will reserve our questions for the end. We're doing pretty well on time here, so we'll probably have ample time to address questions. And if those are questions that Kevin would prefer to talk to you one-on-one about, he'll let us know, and you can follow up with him. So we really appreciate you being here. Kevin, thank you very much for joining us and for telling us more about estate planning. So I'll turn it over to you now.
All right. Well, thank you for the introduction, and good morning, everyone. Thank you, LightHouse, for letting me speak to you all today. As Paul said, I'm a trust and estates attorney. My office is on Solano Avenue in Albany, and I primarily focus just on estate planning and trust and estate administration after somebody passes away. Grew up in the Bay Area, went to law school in San Francisco at USF, and I've been practicing in this area for about 7 years now. For the next 40 minutes or so, we're going to be going over the basics of estate planning. A lot of this information are the things that I talk with clients about in my first meeting. I think it's important before we get into the details to have a lay of the land of what your options are for an estate plan, so you can have an idea of what's the best option for you. This presentation is going to be more tailored to the folks that don't have an estate plan yet, but the content is still relevant. If you already have one and you're thinking about updating it, there'll still be some nuggets in here that will be helpful for you. And if we have time at the end, I'll try and have a list of things to keep in mind if you're updating an existing estate plan. So there'll be the slides that are going to be popping up in a second here. Feel free to follow along if you want, but you don't have to. The slides are mostly text. And I put this the slideshow together as an outline to kind of guide what I'm going to be talking about. So feel free to follow the slides if you want, or review them later. I'll be reading the slides out loud, paraphrasing them as we go. So without any further ado, we'll get going. Andrea, can we get the slides going, please?
There we go.
Thank you. All right. So we'll go to the next one, please. The question I think we all want to ask is, what is estate planning? And in a nutshell, it's coming up with a plan for how to manage your assets and your personal affairs during 2 periods of time. One is if you pass away, and the other is if you become incapacitated. So at your death, the considerations we're trying to think of are who's going to get your stuff after you die, who's going to be in charge of collecting your assets and making sure everything you own is accounted for, who's going to be paying your debt. If you have any minor children, who's going to be the new guardian of that child if the parents are gone. If we're talking about incapacity, that's the second bullet point. This is if you're in a coma, or if you have Alzheimer's or some other condition where you can't make decisions for yourself anymore, or you can't manage your affairs. You want to have somebody in place that can make those decisions for you. So this would be who gets to go to the bank to take money out, or who gets to pay your credit card bills, or who gets to talk with a doctor about what care you should be getting. These are all very important things that should be planned for in advance. The first bullet point about what happens upon your death gets a lot more attention, I think, but they're both equally important. You want to have a plan in place to cover both possibilities, because if you don't, we'll see the alternatives aren't that great. So when we're talking about the plan in the estate plan, it's coming up with a list of documents or some organized structure for how your assets can be handled, and a list of people you want to call on when the time comes to implement your intentions the way that you want them to be handled. And when we talk about estate, it's not the multimillionaires that have estates, it's anything you own. So it's a house, it's a bank account, it's your golf clubs, it's whatever you own that needs to have something happen to it when you're gone. You want to have a plan that covers those things. So the goal with a comprehensive estate plan is to account for all those things that you own and have a system in place for handling them the way you want. So we'll go to the next slide, please. So we'll first look at what happens if you pass away and you didn't do any estate planning. So if you die without a will, the legal term for that is you're said to be intestate, or it's intestacy. And that's the default system in California. If you don't have anything done, your estate is going to be administered according to these rules in the California Probate Code. That's the section of California law that says what happens to your inheritance if you don't make any plans. So who's going to get your assets? It's going to be the nearest living relatives. We just look at the probate code. There's a specific section you go and you look at, and it says that it's going to be your children or your parents or your cousins. Whoever is the nearest family member is the person that's going to get your assets. Or if there's multiple people, they split it at that percentage, but it's set. There's no deviation from that. Who's going to be in charge of your estate? Again, we look at the probate code, and the code tells us that it's going to be your spouse. If you don't have a spouse, it's going to be your kids. If you don't have kids, maybe grandchildren or parents. Again, it's up and down the family tree until you find somebody that's going to fit that role. But again, there's no deviation. You can't have your friend be in charge of your estate because that's not what the law says. So you're really stuck with what the default rules are in the probate code when you're intestate. The probate proceeding really boils down to, probate, the very last bullet point there is probate, which is going to be the thing that happens to administer your estate upon your death. In very few circumstances, you can avoid probate, and we'll talk about those. But if you don't have a will, the most likely thing that's going to happen is a probate administration. We'll go to the next slide, please. So what is probate? That's the default thing that happens in California when somebody passes away. Probate court is a division of the local courthouse. There's family law court, there's criminal court, and there's probate court. A probate is a legal proceeding, just like any other proceeding at a courthouse. There's petitions that get filed, there's papers, there's hearings, there's judges involved. So it's a real court thing. It's just called a probate division is the part of the court that hears it. And that probate proceeding really boils down to accomplishing four main tasks that are here on the outline as first, the court's going to appoint somebody that's called a personal representative of your estate. And that's the person who's going to be in charge of making decisions about what happens to your stuff after you've passed away. Depending on whether you had a will or not, that person might be called an executor or an administrator, but they're both under this umbrella term of personal representative. It's the person in charge when there's a probate. That personal representative, going to the second inside bullet point, they're going to be responsible for collecting all of your assets. So they need to make a list of everything you owned and turn it into the court, because there needs to be a full roster of the things that you owned so we know what's part of your estate. Your debts, if you're deceased, will need to get paid, and there's a special process in probate for handling those. The assets of your estate are used to pay your debts. It's not the personal representative who have to go out of their own pocket to pay your debt. It's the money you had when you passed away is used to pay your outstanding credit card bills or whatever else was owed at the time of your death. But those need to get paid because they're still outstanding debts. And then lastly, when the probate is all done, that personal representative asks the judge for permission to distribute the assets to the beneficiaries. So only when the probate is done will your beneficiaries get the stuff from your estate. There are benefits to probate that are worth talking about. The first is that it's all supervised by a judge. So if there's a dispute with your family about who's going to be getting what, or if there's concerns about one sibling taking advantage of the other. It's all above board in probate because there's this neutral party who is overseeing everything. It's also very comprehensive. For instance, if you know somebody that passed away and they owed you money, there's a specific period of time where you can go to the court and say, I need to get paid back. There's a special form you fill out. And so it's all very clear that all the debts have been paid when we're done with the probate. So family members can be more certain that the estate has been finalized once probate is over. But the drawbacks are significant, especially here in California, if you have to go through probate. The first drawback is the cost. To start a probate, there's filing fees, there's certification fees, something needs to be published in the newspaper, and the newspaper charges $200 for that. So all these fees kind of add up to the cost of showing up to do a probate, and they can be substantial. But the more important cost, or the more significant one, is the attorney fees and the fee for that personal representative. Those are set by California law, and it's a percentage of what's going through probate. So it's tiered depending on how much you have going through probate, but quick shorthand is if you have $1 million in your estate and it went through probate, the attorney would get paid $23,000, and the personal representative would also get paid $23,000. That's a sizable amount that just goes to paying these people for walking your assets through probate. The second drawback is that it takes a long time, especially here in the Bay Area. The courts here are a bit overworked. So you don't get a hearing date right away, but it ends up being at least a year from start to finish before probate can be over. And that whole year is time where, again, your beneficiaries can't get your stuff because we're waiting for the probate to be over before they can enjoy their inheritance. And lastly, this is all, when we're talking about probate, it's a matter of public record. If you wanted to, you can go to the courthouse and sit in on somebody else's probate proceeding and get all the dirt about what's going on with their estate. You can go online and look up records to see if somebody passed away, what they owned when they died, or who received their inheritance at the end of the probate. So if the concern is keeping your affairs private after you've passed, probate's not a good way because it's all going to be part of the public record. Next slide, please. So if you don't want to be intestate, what are some of the options or tools that are available to you? The first one to talk about is the will, and I think we all have a pretty good idea of what a will is. It's a written document that you sign during your lifetime, and it's going to say who gets your stuff when you pass away. It's going to say who you want to be in charge of your estate. It's going to name somebody to be that personal representative. And if you have minor children, it's going to say who you want to be the guardian of those children upon your death. And if you have a will, you sign it, and then it just sits on your shelf until you pass away. Nothing happens during your lifetime to it, but upon your death, that will gets taken to the courthouse, and there's a probate to prove that it was your will and to have your assets distributed according to the terms of your will. Some folks think that if you have a will, you avoid probate, but that's not the case. Your estate will still go through probate if you have a will, but a will is a whole lot better than being intestate or not having a will. Because at least you get to choose who gets your stuff, you get to choose who's going to be in charge. If you want any deviation from that set plan that California has for you, you need to have a will at least to change the percentages, treat your kids differently, or have a charity or somebody else be a beneficiary. You need to have some sort of document in place to make that happen. The last bullet slide there, the probate is required. I guess I just talked about that. Sorry, got a little ahead of myself. All right, next slide, please. So if you're looking to avoid probate, the thing you're probably going to need to look into is what's called a revocable trust. Sometimes it's called a living trust or an inter vivos trust, and they all refer to the same thing. It's I'm going to call it a revocable trust today, but it's a document you sign during your lifetime, and it identifies somebody to take care of your assets and distribute them upon your death. People often name themselves as this person who's in charge. We call them a trustee of the assets, but upon a death or incapacity, you can't be in charge of your assets anymore, so you pick somebody to manage it for you. The effect of having a trust is subtle, but it's very important. An analogy I use often is this idea of a bucket, where instead of holding all the assets in your hand, you have a bucket that you put the house and you put the bank account in, and you are no longer holding those assets, but you're holding a bucket that all these assets are held in. And why that gets to be important is upon your death, nothing you own has to go through probate because you don't own anything. Everything that you own is in this bucket, and you already have some instructions set about what's supposed to happen to the stuff in that bucket. So whatever's in the bucket doesn't have to go through probate because you already had set aside a plan for that. You also will be picking somebody else to be in charge of that bucket or to follow your instructions. We call that person a successor trustee or a backup trustee. But with that structure of a revocable trust, your assets don't need to go through probate because they're being managed for your beneficiaries. The third bullet point talks about how a trust is a disregarded entity during your lifetime. And what this means is that the IRS doesn't care about your revocable trust. The county assessor doesn't care about your revocable trust. You're still the owner of all the assets inside of your trust. It's just a slight name change. Instead of you as an individual owning your house, it's you as trustee of this trust that you set up and that you control, and you could revoke at any time. And that's the same level of control as owning it outright. Nothing's going to change with your taxes. Nothing changes with your property taxes when you put a house into a trust. You're still the owner because you get to enjoy the property the same way before and after the trust. And again, that last bullet point reminds us that you don't have to have your assets go through probate if they're in the trust. The trust is the thing that says what happens to your assets. So in a confusing way, it's sort of like a will. It's doing a lot of the same things. It's saying who gets your stuff and who's going to be in charge, but it's happening outside of the courthouse. So a lot of the same things are going to get done. It's just more informal, and you don't have to go through the probate. You don't have to pay the expenses of probate. There's still attorney fees and things, but on the whole, it's less expensive and a quicker process than if you had to go through probate. Next slide, please. So this slide talks about two other tools that come up in estate planning meetings for planning for your assets. The first is beneficiary designation. So some of the assets you own, such as retirement accounts or life insurance policies, those are going to have what's called a beneficiary designation, where you can select who gets those assets upon your death. So when you sign up for your IRA or your life insurance, they ask you, when you pass away, who's going to get this account? And whatever name you give them is going to be the person who receives that asset. So in a sense, it's a contractual agreement because the company, if it's Vanguard or MetLife, is bound to give that money to whoever you fill out on that form upon your death. The important thing to keep track of, though, is this cannot be changed by your will or your trust. So if your will says, I give everything to person X, but person Y was the person you named on your beneficiary form, person Y is going to get that IRA or life insurance because your will can't change your beneficiary form. So it's important to make a list of all the assets you own and figure out which have those beneficiary forms and make sure they're filled out the way you want, ideally to complement what's going on in your will or your trust, that maybe have the same beneficiaries or the same structure, but don't forget about them because your will or your trust can't cover those things. So examples of where you'll find those accounts, again, life insurance, retirement accounts, and there's something called a pay on death account. That's, you can go to the bank and say, I want my checking account to go to this person when I pass away. Those are all beneficiary forms that you want to be tracking and making sure they're current. The last little bit here is about joint tenancy, and this is a special word that's a particular form of how you can own property with somebody else. If you take title to a house, let's say, or a bank account, and it says joint tenants, or it says right of survivorship, those are magic words that mean that when you pass away, the half or the third, whatever you own, automatically goes to the surviving co-owner or co-owners. There's no probate, there's no trust, it just automatically goes to that person. So this is commonly with bank accounts, but sometimes the house will be in joint tenants if you have it with your spouse or a non-spouse, or investment accounts are sometimes set up this way. You look for the abbreviation JP, JTROS, right of survivorship. You just try and figure out if that special form is showing on the title, and if that's the case, automatically upon your death, it goes to this other person. Usually that's not the best way of having a plan because it's strict. If that person predeceases you, there's nobody to give that half to or the third to, so it kind of ties your hands in terms of having a good plan for what's going to happen to that asset. But in the right case, sometimes it's a useful tool to rely on for a bank account or something like that. Next slide. So changing the conversation a little bit, we're going to chat about incapacity planning. So again, incapacity is if you can't make decisions for yourself because you have Alzheimer's or you're in a coma or any other condition where you can't manage your affairs. what's going to be the plan for making sure things still run smoothly for you. So this slide talks about the two major documents that are part of an estate plan for this incapacity planning. The first is called a durable power of attorney, sometimes called a financial power of attorney. And this is a document where you appoint someone to act on your behalf to make financial decisions for you, such as getting money from the bank, signing your tax return, paying your credit card bills, the normal financial stuff you do because you're you. If you can't do them anymore, we need somebody to step in and kind of pick up the slack there. So you can appoint somebody to do that with a financial power of attorney. The second point under that says that this can be either effective immediately or upon incapacity. And this is, again, depending on your situation, but you can have this person be able to act right now for you. That would be effective immediately, or you can have that person only able to act once you've been deemed to be incapacitated or not able to act for yourself. Sometimes spouses want to give each other the immediate ability to act so they can take care of something really quickly. Other times it's more prudent just to wait until there's been a capacity determination. That's something you have to figure out when you're doing these documents. Do you need it now, or can we wait until you're actually incapacitated? So the second half of this slide addresses the Advanced Healthcare Directive, and this is the corollary to the financial power of attorney. Durable power of attorney or financial power of attorney is for finances. The Advanced Healthcare Directive is who gets to make decisions relating to your health or medical decisions for you. So the first bullet point, you're going to be appointing somebody to tell the doctor about your care and to make other medical decisions for you. This is every form. This is usually a form. Attorneys sometimes prepare them, but they all have two parts. Part one is who's going to be the person you want to make decisions for you, and maybe some backups in case your first person's not around. And the second part is what instructions do you want to provide this person to guide them in making decisions for you? Do you want to be kept alive or not kept alive? Do you want to be buried or cremated? Do you want to have a DNR? So all sorts of instructions you want to be providing. The form lets you be as extensive as you want to guide this person. Ideally, you'd also have a conversation with the person you've named, but the form itself is just to capture who you want to be in charge and some guidance for them so they can pick it up and know what they're supposed to do. The Advanced Healthcare Directive is effective when the doctor can't communicate with you. So as long as you're able to tell the doctor or anybody else what should be done in terms of your care, they're going to listen to you. But if they can't communicate with you, that's when they look to this form to figure out who is the person that should be giving them instruction about what to do. And this is a document that everybody over the age of 18 needs to have. A healthcare directive. There's no law in California that says that your spouse or your child automatically gets to make these decisions. It's really up to the medical provider to figure out who they want to listen to at that time if you don't have a healthcare directive. So if you become incapacitated, you really need to have one of these forms filled out in advance to make sure that somebody's able to advocate on your behalf, because this is a lot of tricky issues sometimes where family members can be fighting. You make it a lot easier on everybody if you can be clear from the beginning. Next slide, please. So as a point of comparison, if you didn't do any planning before you became incapacitated, the thing that's going to be happening is called a conservatorship. And that's the way that the probate and the intestacy is if you didn't do any planning for you pass away. A conservatorship is if you didn't do any planning, the court gets involved upon your incapacity. So the court appoints somebody called a conservator, and they're going to be the ones who manages your affairs. Again, two types. There's a conservator of the person, so they handle the medical decisions, and there's a conservator of the estate. That's the person who handles the financial decisions for you. But again, the reasons we don't like probate are the reasons we might not like the conservatorship. It takes a long time to get set up. It's all in the public. It's a hearing to figure out whether you have capacity. It's in open court, which can be a tough day for a lot of the family members. It also is costly. There's attorney's fees, and the maintenance of having it go can add up, and they can be nipped very easily by having a power of attorney or an advanced healthcare directive that's halfway good. As long as you're giving somebody the authority, you don't need to have a conservatorship put in place for you. Next slide, please. So this next slide kind of addresses some of the confusing vocabulary that shows up when we talk about wills and trusts. Unfortunately, there's revocable trust, and if there's revocable, there must be irrevocable trust. The first bullet point, revocable trusts are for asset management during incapacity and probate avoidance. So this is the bucket idea that I was talking about earlier, where you want to have your stuff avoid probate, you have a revocable trust, because that means you could change it at any time. If you need to update who's getting what or who's in charge, you can do that because it's a revocable trust. On the contrary, there's irrevocable trusts out there that people use for advanced tax planning, if that's income tax or estate tax or creditor protection planning. Very rarely is an irrevocable trust the thing most people need. Because it's irrevocable, you can't make changes to it, and you lose control over the assets when it's in an irrevocable trust. So when you talk about estate planning, or people are talking about estate planning, they're mostly talking about these revocable trusts. But there are irrevocable trusts out there that sometimes are relevant depending on your situation. And the bottom of the slide has some more confusing words. You can have a trust come out of a will. We call it a testamentary trust. That just means that your will says, when I die, I want there to be a trust for my kids, so they don't get all the assets at 18, they get it at 30 or 35. You can do that. It still has to go through probate court, but you've got a trust for your kids. The last bullet point addresses this idea of a pour over will. And again, at the risk of confusing us a little bit more, when you have a trust, you still want to have a will. It's a special kind of will, though, called a pour over will. And what it does is it says, I know I have this trust, it's got my house, it's got all my stuff, but if I forgot about something, I want that thing I forgot about to end up in my trust, because my trust has all these great provisions about who's going to get my stuff. So your will is going to be a special kind of will called a pour over will, where it says, whatever's in my estate that would go through probate, have it go into my trust so the trust can handle it. So if somebody asks you, do you have a will or a trust? If you have a trust, technically the answer is I have both, but the trust is the thing that's doing the lion's share of the work as part of your estate plan. All right, next slide, please. So factors when we're trying to choose between a will or a trust, what are the things we want to be keeping in mind? The first item is, what are the assets you own? Would an asset otherwise need to go through probate if it wasn't in a trust? That's a good question to ask yourself. If you own everything with joint tenants with somebody, or if everything you own is through a beneficiary designation, those things aren't going through probate. So you might not need a trust because you're avoiding probate anyways by the structure of what you own. But if you own a house by yourself, or if you own a bank account that's just in your name, those are things that would go through probate unless you had a trust. And so you might want to figure out, is it worth the time to set up a trust to care for those assets? The second item here is, what are your goals for the estate plan? And specifically, how much control do you want over the gifts to your beneficiaries? If your plan involves some sort of control over how the funds are going to be used, you don't just have a will that gives it all to the child. You want to have a trust that's set up that says they get the money over time, or this money can be used for this reason or that reason. So it might make sense to have a trust if we're trying to pull some strings after you're gone to make things happen the way you want. And the last item here is the cost. Generally, a revocable trust is more expensive for attorneys to prepare, or we charge you more than a will, because it's more work up front, but the savings is on the back end. If you have a will, it's cheaper to set up now. You could write your own will, but it's going to be going through probate, and there's more expenses at the end. So the question you ask yourself is, do I want to spend more money now to get a trust set up, or do I want to have the expenses be showing up later when there's going to be the probate that has to happen? Next slide, please. So one of the more important parts of the estate planning process, or coming up with a plan, is choosing the right people to fill all these roles for the documents that we talked about, these positions of responsibility. The umbrella term for these people, they're called fiduciaries. So this slide is about choosing the right fiduciary. And that's going to include the executor of your will, the trustee of your trust, the agent under your healthcare directive or your power of attorney, who's going to be the people in charge. And it's up to you to figure out who's going to be a good fit based on who you know and what their skill sets are. But this slide has a couple good qualifications you want to be thinking about when you're picking people. The first, and maybe most obvious, is you want to be able to trust this person because they're making decisions for you. They might have access to your money or to your house if you're incapacitated. So having somebody you have some relationship with, and they're not going to leave the country with your money, that's a great first start for who you're going to be choosing. You also want to be thinking about, is this person you're going to be picking, are they able to do this, or are they willing to do it? If somebody's working 50 hours a week and they've got 3 kids and this would be an extra thing on their plate, maybe they're not the best choice because the quality might not be as good, and you're really putting more on their burden side than you want to be, or they want to be handling. So you want to be thinking, is this person able to help me out? Is it asking too much? Sure, they get paid to do this job, but it's a lot of work sometimes. And you want to at least have a conversation internally, if not with that person, about whether they want to take this responsibility. The third bullet point here is that someone local might be a good choice, but it's not a requirement. And these days, if something needs to be signed, there's FedEx or UPS, you can ship a document to get it signed. That's not as important. But if something needs to happen at the house, if somebody needs to go meet a realtor at a house, or especially with the healthcare directive, if somebody needs to get to the hospital to make a decision, having somebody local is going to be a lot easier than waiting to make a decision until the person from the East Coast flies in and then you get to talk with the doctor. That would be a waste of time, I think. So if you're able to find somebody local, it's helpful, but especially for the healthcare directive, maybe it's more so to have somebody that's around nearby. The last bullet point here, co-fiduciaries are discouraged. Oftentimes I'll have parents with 2 or 3 kids, and they want to treat all their kids equally, and they say, I'm going to name all of them as co-decision makers. I want them all to share in the responsibility. I really try and discourage that for a couple of reasons. First is you're assuming they're all going to get along and come up with the right answer. If any one of them says, no, I don't think that's the right idea, nothing's going to get done. And even if they do get along or they all agree, you're still waiting for 3 signatures. You might have to have 3 people show up at the bank at the same time. Sometimes banks don't even want to deal with multiple signatures because they don't know how to set up that account. Can one person get money out? Do all 3 have to sign to get money out? So they would often prefer to have one person. So it can be done. You can have co-decision makers, co-trustees, but really have to ask yourself, why are we doing it? Is it a quality issue? If that's the case, maybe just make sure they're receiving everything equally, but have one of them be the first person to make decisions. And there's checks and balances in this whole system of, if any child is not the person who makes decisions, they're not going to get shut out of all the information. They still get to ask what's going on. They get records. It's just picking the person that gets to interact with the bank or meet with the CPA or meet with the attorney. Usually that's best by one person. Next slide, please. So when it comes to figuring out who's going to receive your assets upon your death, this slide talks about some of those considerations about how to leave your estate. The first bullet point is, who do you want to benefit? So this is pretty simple. Who do you want to get your stuff upon your death? You can set it up as a specific gift. You can say, I want to give $100 to this person or to this organization. You can also have it be what's called a residual gift, where if you're going to split your estate into quarters or whatever's left over, you can say, I want a quarter or the whole thing or a half to go to different people. So it really depends on how you want to be benefiting people. Again, with the idea maybe your assets go up or down in value. So just different ways you can structure a gift inside of a will or a trust. The second bullet point is, how do you want to benefit these people? So again, is it appropriate to give them a lump sum, or do we need to have a gift with some restrictions on it or conditions, in which case maybe the trust makes sense. So if you have a kid who's not 18 yet, they can't inherit assets because they're minors. So you want to have a trust in place that's going to be able to take care of the assets for them until they reach a certain age. And lastly, it's always a good idea to have a backup plan for all of these contingencies. So if your preferred beneficiaries, God forbid something happens to them and they don't outlive you, who gets your assets at that point? Is it their kids? Is it somebody else? You don't need to plan on every contingency, but at least having the first couple that might happen, having those addressed in the documents will be helpful, because it could happen. And if it did happen and you didn't plan for it, maybe something happens where you didn't want it to happen, or maybe that's when we default into that intestacy land, where it just goes to your nearest relative who you haven't talked to in 30 years and they inherit your entire estate. So having at least maybe an organization or a person as the backup beneficiary is a good way of preventing that from happening. Next slide, please. So this slide is a picture of a baseball player, Yogi Berra, and a quote of his that I like. It's tough to make predictions, especially about the future. I know it's really difficult to think about who's going to be your trustee or executor, or who's going to get your assets upon your death, because that's going to be many years from now, and your assets are going to change over time. And sometimes that gets people to not think about this, or get a little bit too in the weeds about what should be done. The plan that I think is not a bad one is, I call it the 7-11 plan, where you try and get an estate plan that makes sense for the next 7 to 11 years. So you think, who's going to be around reasonably in the next 10 years or so? Who's going to be the person that you want to benefit with your estate as it currently is for those next 7 to 11 years, and have that be your plan, and just be open to the idea that at the end of that 7 to 10 years, you might need to change it, because that's going to be the reality. People are going to move into your life or out of your life. People that said they could help before might not be able to help. The people you want to benefit with your estate will probably change over time, either the size of your estate, or you might have new beneficiaries you want to be adding. So it's oftentimes you get the best estate plan if you go into it just knowing that there might need to be an update in the future. You're not trying to stick the landing right now with a plan for your death. You want to have it cover a chunk of time that's going to be most realistic. And all these documents can be updated very easily as long as you have capacity to make updates to your documents. So if you need to update your trust in 7 to 10 years, as long as you're not in a coma or can't make decisions for yourself, then yes, you can do anything you want to change who gets your assets, or who's going to be in charge of your will, or who makes medical decisions for you. So that's the benefit of this type of planning, is as circumstances change, you can adapt and adjust to have a plan that makes sense for you. Next slide, please. So this slide introduces the concept of the estate tax. And so this is a special kind of tax that gets paid when you pass away if your estate is of a certain size. Every year, the federal government has what's called an exemption amount, where if your estate is over that amount, you get to pay the federal government 40% of the amount that's over the exemption amount. So as an example, the current exemption amount for this year is $11.58 million. As you might imagine, that's not a lot of people that are paying the estate tax, because not a lot of people have an estate over $11.58 million. But that number didn't always used to be $11.58 million. In the 1990s, I think it was $600,000. In the 2000s, it was $2 million. It was the most recent tax law that went into effect that bumped this up to $11.58 million. In 2026, as part of that tax law, it's supposed to go back down to $5 million, adjusted for inflation, so it creeps up a little bit every year. But this is something that Congress can change at any time. If there's a new tax law, if there's a change in the administration or the members of Congress, and they want to have a more progressive policy that increases revenue, this is a number they could bring down to increase the amount of, or the number of estates that might be subject to estate tax. And again, it's 40% of what you're over. So right now, it's a bit of an area of confusion for estate planners, because we don't know what this number is going to be when people pass away, but it's something to keep in mind. If you're at all close to what the exemption amount is now, or what it might be in the future, maybe there's something you do with your estate plan to solve for the estate tax problem. The very last slide here points out that some states, I'm sorry, if we can go back one slide, please, thanks. The very last bullet point, some states have their own version of the estate tax. So if you own property in Oregon, or some of the states on the East Coast, they have estate taxes of their own, and usually it's a lower exemption amount than the federal government. So in Oregon, if you have an estate over $1 million, you pay an estate tax to the state of Oregon. California currently does not have a state estate tax, but last year there was a bill that was introduced that would have had an estate tax in California, and it would have been for estates over $3.5 million. So a lot less than the federal government. So if you had $4 million, you'd be paying the state of California a little bit of estate tax, even though there's nothing at the federal level. That bill didn't pass, but it's something we have on our radar, because there might be a need for the state to generate revenue. I know with all the COVID stuff, the state is spending a lot of money. There might be a call to increase revenue, and this would be an easy way of doing that. So it's not in place now. You don't have to worry about it, but it's something that could come up and change the need to have some estate tax planning as part of your estate plan here in California. Next slide, please. So this slide is talking about California real property taxes. Many of us are familiar with Prop 13. This was the proposition that passed in the 1970s. It limited the amount that your property taxes, if you own a home or other real property, can go up every year to 2% every year. Other states, the property taxes are changed every year based on the fair market value, but not here in California. You get to keep the same property tax value for as long as you're owning the property, until there's what's called a change in ownership. So if you sell the property, that's when there can be a new tax value. That process is called reassessment of the property taxes. But how it relates to estate planning, whenever you pass away, the assessor says that's a change in ownership. The ownership of that property is undergoing, there's a new owner of the property. And so that's the time when they can reassess the property taxes. So to bring it up to current fair market value. So if you own your house for 60 years and you've got a very low tax basis because you're benefiting from this Prop 13 and it hasn't been sold, upon your death, if you gave that property to your neighbor, they're going to be receiving the property, but they'll have to pay a new property tax every year that's based on the fair market value of that property. So here in the Bay Area, property is worth a lot, and so the property tax would be 1% of whatever the value is of the house. So that could be an exponential increase in what the property taxes were before. There's some ways around that exclude the property tax reassessment, and that's what the last 3 bullet points here are. If you give real property to a spouse or to a registered domestic partner, they'll let you keep the same property tax level. If you give your property to a child or to your parent, they'll let you keep the same property tax level with a limited exception. They cap, it's not an infinite amount that you can give to a parent or to a child, but it's substantial, $1 million worth of assessed value. And if you have grandchildren, but there's more limitations on that transfer, it has to be the parents of that grandchild are also deceased, that you can give it to a grandchild. But if it's property to a niece or a nephew or to a friend, or like I said, a neighbor, those are all events where upon your death, there'll be a new property tax for that property going forward. And as long as they own the property, they're going to have to be paying that. All right, next slide, please. So this slide talks about a little bit more about retirement accounts and beneficiary designations. The top half of the slide addresses beneficiary designation forms. And again, we talked about these as the important thing that you want to be filling out for life insurance retirement accounts. Who gets the balance of those accounts upon your death. Every form is a little bit different, but they have 2 levels of beneficiaries. There's what's called a primary beneficiary. That's your first choice of who you want to get your life insurance or your retirement account. And then there's a contingent or a backup beneficiary. So if your primary beneficiary didn't survive you, you can list on this form who the backup or the contingent beneficiary is going to be. And it's important to fill out that second part, the contingent beneficiary, because if your first person doesn't survive you, those assets might be subject to probate because they're payable to your estate if you didn't name anybody. So if you have an IRA and you never named the beneficiary, which is hard to do, but it's possible, or if your beneficiaries, which is more likely they pass away before you, and you didn't have anybody living to receive that account, those assets would then go through probate. So even if you had a trust that handled the house and the bank account, you could still have a probate upon your death if the forms weren't filled out. So again, make sure those are going to be filled out comprehensively to prevent intestacy for those assets. The last half of this slide is addresses a new law that went into effect in this year. It's called the Secure Act. It had a lot of different components. It changed how retirement accounts were going to be handled in terms of when money, every year, if you're retired and you're taking money out, you have to take minimum distributions. It changed the start time of that, but how it affects us as estate planners, it changed how quickly somebody can take money out of an inherited IRA. So if you have an IRA and you pass away and you give it to your child, let's say, before the Secure Act, your child would have their whole life to take out that money. They got a little bit every year, but don't have to take it out all at once. They could wait their whole lifetime and take out the minimum amount that the IRS says they have to take out every year. What that was called a stretch out of an IRA. What the Secure Act is it says we're not going to allow that anymore. We're going to change it so you have to take the money out within 10 years, sometimes 5 years, but it's 10 years now that your child has before they need to take all that money out. And why this is important is when the money gets taken out, that's when you have to pay some tax on it if it are taxed. So this would be for traditional IRAs, not the Roths that have already been taxed. But this is a different way of how these accounts are handled now. Before, it was very easy. If you had kids, just make sure the IRA got to them because they got to enjoy the lifetime benefit of having it grow and not having to take it all out. With this new law, maybe not the case anymore because the child is going to be increasing. They won't be able to have increased over time, they'll have to go over 10 years. So it's just something to consider as part of your estate plan. Who do you want to benefit? Maybe it's no longer a no-brainer to give it to your kids pretty younger than you. Next slide, please. So this slide lists a couple of other items that pop up when I'm working with folks on estate plan that I thought might be helpful about. The first, a good estate plan is going to make some provision for your personal property items. So this is the stuff around the house. This is the car, the things that you own that are tangible personal property. Some people want to make specific gifts of these things, a specific chair or a painting that could go to a certain person. Those instructions you can have in your trust or your will, or you can have a separate instruction that says who gets your personal property. It really depends on how significant gift it is, or people are going to over it, and you probably want it in your trust or your will because that's a more formal document. But if everyone's on the same page, you can get by with having a separate writing that says what's that. Also keep in mind, a lot of this stuff might not have monetary value, but it might be really sentimental to people in your family. And so you might not think it's a big deal, but having a clear way of handling the property might make it easier for them. So there's not missed expectations about what was supposed to happen. You already have a plan in place of who's what. It can be very clear. So the more direction you can give on this front, the better off everyone's going to be. The second bullet point, you can go forward, slide, Angie, please. Or 2 slides, I guess. There we go, thanks. Digital assets. So these are the question that we wrestle with here is who's going to have access to your email account if you pass away? Who's going to be able to update your Facebook or close your Facebook account if you pass away? Who's going to get access to your iPad or other devices if they're password protected upon your death? A good estate plan is going to have some language in there that addresses this question. But some platforms like Google, Facebook, they have a setting where you can name somebody that you want to have access to your digital assets upon your death. With Gmail, if you have Gmail as your email, I believe it's inactive account manager is the setting you can look for. And that's really helpful because in the good old days, a lot of the statements that you might need to find out what somebody owned after they died would show up in the mail. So you just watch the mailbox and see what came in. But now a lot of things are coming by email. And so if you can't access the email, maybe you don't know about an account that's part of somebody's estate, and that can really slow things down. So obviously you don't want to do this to somebody you don't trust, but if there's, as part of an estate plan where people are in place to make these decisions for you, there might be an affirmative step you can take with these digital platforms to make sure that they're going to be handled the way you want. Pets are on here because technically they're assets. You can give pets away like any other personal property. With the estate plan, you can go into as much detail or as little detail as you want. It really depends on the pet and the circumstances, who you're trying to give them to. California lets you set up a trust for your pet, but that's a bit of an extreme planning option for most people, but it might make sense for you. So if you have a pet you're trying to care for, it's worth trying to figure out what options are best for making the pet comfortable and provided for if you can't do it yourself. The very last bullet point is relevant for us, charitable giving. As Paul discussed earlier, you can name charitable organizations as beneficiaries for a lot of the assets or the elements of your estate plan, excuse me, your will or your trust, or they can be a beneficiary of a retirement account. For my clients who are charitably inclined, it's usually a good strategy to have those tax deferred accounts, so those IRAs may be named to a charity because they don't have to pay income tax on it. If you gave that money to a person, they'd have to pay the income tax when it comes out over time, but a charity can enjoy the full amount of that gift. So if somebody has charities and people they want to benefit, maybe it makes sense to have the charity be the IRA beneficiary and the person be the one who gets the cash from the trust, because that's not going to be taxed when it's given to them. So there's some, not manipulation, you just want to be a little bit smart about ways to maximize what people are getting upon death. And if you're thinking about naming a charity, this might be a little bit obvious, but maybe call them or check out their website to see what particular way they want to be identified in your will or your trust, or if it needs to have certain language in there. Some charities also have specific programs that they employ that you can have your bequest or your gift funneled directly to that particular cause, and they'd be able to walk you through whether that's an option, what language you need to do, or if it's a general fund that you can contribute to. If you're working with an attorney, you'd want to forward any instructions from the charity to that attorney so they can make sure it ends up in your documents, or the attorney can work with the charity depending on how you want to have them involved. Next slide, please. So the last slide in the deck here is a quick list of things that might be a good thing to have on hand if you're meeting with an attorney to talk about setting up an estate plan. The first is a list of your assets. Every meeting I have with people, I need to know what you own so we can figure out what the plan should be for those assets. You want to make a list of the names of the proposed beneficiaries and those fiduciaries. So who do you want to get your stuff to, and who do you want to be in charge? And then it's up to the attorney to talk with you about what's the best way to incorporate these people into the plan. You'll want to come up with a preliminary plan for how to distribute the estate. So you don't have to have the answer. The attorneys often will guide you through some good ideas or some avoiding bad ideas, but you should give some thought before the meeting to what you want to have done. And then the last bullet point here is a backup plan. So again, operating on the assumption everything goes the way we want it to, but if it didn't, who's the backup beneficiary? Who's going to be the second person on the roster to make decisions for you if number one isn't around? These items here are also at the beginning. I think we're doing all right on time, but these items here, if we're talking about updating your estate plan, these are the same questions you want to be asking yourself. Is the assets you own when you set up the plan still the assets you own? Are the proposed beneficiaries and fiduciaries that are in your last plan, are those still people you want to be involved in your plan? Is the distribution that you had in mind something that still makes sense now? Or... Sorry, did somebody say something? Okay. And so when you're reviewing an estate plan, also a couple things to keep in mind, as I said before, if you have those assets that have beneficiary designations, you'll want to make sure that those forms have been updated recently, or at least you confirm that it's still who you want to be the ones who are named on those forms. And if you have a trust, really the thing you want to be keeping track of is everything that should be in that trust actually in that trust. Sometimes you'll have a house that was put into the trust, but maybe you refinance it and it had to get taken out of the trust to get the loan secured, and it never made it back in. So it's always a good exercise to make a list of what was in the trust or what was should have been in the trust, and make sure it's actually there, because it needs to be in the trust in order for it to avoid probate. So that's the end of my spiel. I'm happy to open up to questions, and I'll turn it over to Paul or Andrea to facilitate those.
Great. Kevin, thank you. That was great. Lots of information. These are things, themes that I think are on people's minds. And when I introduced this workshop, we talked about our legacy society at LightHouse. We have lots of people who are interested in naming LightHouse in their estate. And obviously there are many steps to go through to make that decision, but there's also some formality and enlisting the help of somebody like Kevin. But LightHouse benefits tremendously from these gifts, and we have in exceptional ways. Sometimes it's a surprise to us that we've been named in people's estates, but we also have very strong relationships with people that have conversations with us about what their plans really are and how LightHouse will benefit from their estate. But there's also tax implications and details that Kevin could probably address with you, where there are some benefits to you. Charitable giving, there will be some benefits to you. So it is a theme that we like to keep active in our donor community. We do have this service available. Kevin obviously could be somebody that you could discuss with your plans for an estate, but we hope that everyone will consider estate planning, and also consider nonprofits or charitable organizations that they're connected to. And for those of you that have been involved with LightHouse for a very long time, we would love to talk to you more about ways to support the organization now and in the future, and after your death. So I'd like to open it up to a few questions if we have any, and I think I can do that through chat. Or it's possible that I could open it all up, Andrea. Perhaps this might be a risk, but to unmute everyone. We don't have a lot of time. What time is it? Oh, we have about maybe seven minutes to address some questions that Kevin may be able to help us with. So I'm going to go ahead as an experiment and unmute everyone. So let's see how I can do that.
Paul, they can unmute.
Oh, you can unmute yourself. Okay. Is that what you said, Andrea?
Yes.
Okay, thank you. I'm still learning the ropes here and how to do all this. So thanks to Andrea sincerely for doing all this for us. So if you have a specific question, you can go ahead and unmute yourself. I'll identify your name and Kevin can address the question. Or if you don't have questions now and you want to filter them through me, I can get them to Kevin. Or with Kevin's contact information, you can discuss with him directly questions that you may have about LightHouse and how you might be able to set up something in your estate plan that will benefit you and a charity of your choice. Any questions here? Nope. It's a lot of information to digest. With this recording, it will be made available to everyone, and the slides as well. You all received those. And I hope that, first of all, I will directly follow up with everybody individually, talk a little bit more about the workshop. And we're always open to ways that you suggest that may improve the content of these workshops. And perhaps Kevin will be back with us in 6 months or so to talk a little bit more about estate planning. Please spread the word to people in your circles that may be interested in legacy giving. And even if there are people in your circles that are not necessarily interested in legacy giving but want to get to know more about LightHouse, we want to spread the words through the community, our established community. So please spread the word. We're still here, even though we're working remotely. Legacy giving, I can tell you, is something that people are more interested in than they were in the past. And our legacy society is growing. And it's also possible if you wanted to talk to someone that's established in our legacy society, we could put you in touch with them and they can tell you perhaps what their process was and why they identified LightHouse and which attorney they worked with and why they actually decided to name LightHouse in their estate plan. So, yep.
Arnold, question, and he's unmuted.
Yes.
Okay, thank you. Oh, Arnold, sorry about that. Thank you,
It's
Andrew.
okay.
Go ahead, Arnold.
Yeah. My question is to Kevin is, what is the difference between a property tax and an estate tax?
Oh, Kevin, you're still muted. Sorry, I have to ask you.
Thanks.
Thank you. I saw that. Got the hand signal.
Yeah.
Thanks. Sorry.
Yeah, Arnold. So the property tax is the county that you live in. Every year you pay them in 2 installments. If you own property, a tax to own that property. The estate tax is upon your death. The federal government now has a tax where if your estate is over a certain amount, they tax you on the amount that you're over, that exemption amount. So the property tax you're paying every year as long as you're alive. The estate tax is only when you pass away, and it's based on the size of your estate, so including the real property and any other assets you own.
Thank you.
Good. I have a question, Kevin. Something that you mentioned, I think in the first couple of slides, when a will goes into probate, that the probate court actually can request payment for the services that they provide, as well as the executor of that estate working in tandem with probate would also be paid out of the estate. Did I hear that correctly?
The probate court is supervising all this, and at the end of the probate, the attorney who was helping the estate and that person who's in charge, the personal representative, they're entitled to get paid a percentage of what went through probate. So they get paid at the very end, but depending on the size of the estate, they're entitled to get money from the estate to pay themselves in the way that all the other expenses that come up in a probate, those filing fees I was talking about, those are all paid from the estate. But the attorney fees and the personal representative fees are the most substantial amount that gets paid, and that's at the very end from the estate.
And that is public record to know how much each of those entities was paid from the estate?
Yes, so the final court petition says this person got paid X amount of dollars to be the personal representative for the administrator. The schedule for paying somebody, it's 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, so you get up to $1 million, and then 1% after that. So larger the estate, the smaller the percentages, but it's still a sizable amount of money.
Excellent. Thank you very much. So I don't see any more questions here.